Hi, ladies and gentlemen. My name is Paku Khan, and I'm the Executive Director of Kethan & Co.'s Competition and Antitrust Team, speaking to you today from New Delhi, India. Today, our topic is going to be 10 things that you must know about the new Indian competition regime, and I really want to thank you for your participation today.
Let's start today by giving you a brief outline of today's presentation. First of all, I'm going to give you a brief overview of the Competition Act 2002 in India, and today we're going to call it the Competition Act. And then we're going to get to the 10 things that you must know about the Indian competition regime. And just for one point of order, we're going to cover merger control issues first, and then we'll deal with enforcement issues relating to anti-competitive agreements, both horizontal and vertical, as well as abuse of a dominant position later in today's program. Now let's get to the major sections of the Competition Act. The first one is Section 3 on anti-competitive agreements, and this went into effect May of 2009. This section covers both horizontal agreements, including cartels, and these types of agreements are presumed to be anti-competitive. In other words, that they are presumed to cause an appreciable adverse effect on competition in India. That's a rebuttable presumption, however. The second type of agreement that's covered by Section 3 are vertical agreements, and these are going to generally be adjudged under a rule of reason. So, effectively, what that means is that a vertical agreement, such as an exclusive distributorship, needs to cause or be likely to cause an appreciable adverse effect on competition in India before it can be considered problematic under the Competition Act. The next section is Section 4. Again, this also went into effect May of 2009, and this one relates to abuse of a dominant position. One thing that I would like to add on both Section 3 and Section 4, which we're going to refer to today as the enforcement sections, is that any kind of sanction or punishment under the Indian regime for a breach of either of these two sections is going to be civil in nature. So the key regulator here in India, the Competition Commission of India, or the CCI, has the ability to levy fines, but generally will not be able to levy imprisonment except for repeated contempt of orders of the CCI. So it's important to keep in mind that India is predominantly a civil jurisdiction, and the criminal sanctions only come in where there is an order in place by the CCI and that order is repeatedly refused to be adhered to by a particular party. And the last major section went into effect in June of 2011, and it's sections 5 and 6, which deal with merger control, or it's referred to in India as combination control or combination regulation. Now, let's talk about the substantive issues and the substantive sections and the key issues. And this is going to be issue number one that you need to keep in mind about the Indian competition regime. First, we're going to talk about merger control, and then we'll talk about enforcement in the next slide. Now, with respect to merger control, under sections 5 and 6 of the Indian Competition Act, all mergers and acquisition transactions after June 1, 2011 that meet certain financial thresholds, which we'll get to in a minute, would be deemed combinations. And combinations must be notified to the CCI unless the transaction benefits from either a statutory exemption or several informal exemptions that the CCI has promulgated through regulations. It's very, very important to understand that if a transaction qualifies for mandatory notification under the Indian regime, one must file the transaction within 30 calendar days from the trigger document or the triggering event. For acquisitions, that would be 30 calendar days from the execution or signing of the definitive acquisition agreement. And for mergers and amalgamations, it's 30 calendar days from the date of the Board of Director resolutions approving the merger or amalgamation transaction. Now, failing to file a transaction can result in fairly substantial penalties up to 1% of the turnover or assets of the transaction or combination for failure to file, whichever is going to be higher. And in fact, the CCI is levying penalties for gun jumping and late filing, which we'll get to later in the program. Now, as I said earlier, there's no concept of voluntary notification in India. It's mandatory, meaning that if you qualify and no exemption applies, you must file. By contrast, if you don't meet those threshold qualifications, then you cannot file. It's also important to understand that non-notifiable transactions, these are transactions where the thresholds are not met or no formal or informal exemption apply, could still violate the enforcement provisions of the Competition Act, namely Sections 3 and Sections 4. Now, the slide in front of you is, I think, one of the most important slides we'll talk about today. And I want you to take away the message from this because it's very important to understand the enforcement regime for competition law in India. First of all, in India, one doesn't file a complaint, one files an information. And an information can be filed by anybody, any person or any company, or even the CCI itself on its own initiative. And it's quite easy to file and actually quite inexpensive to file. For a individual filing a complaint or information, it's no more than 5,000 rupees, which is at current rates quite a bit less than 100 US dollars. And even for the biggest company to file a complaint or information with the CCI, it costs no more than 50,000 Indian rupees. And at today's current exchange rates, that's well under $1,000. And that's going to be important for what we talk about near the end of this slide. Keep that in mind. Now, what happens when a complaint is filed with the CCI is that the CCI then looks at that complaint or information and then makes a prima facie determination as to whether there may actually be a breach of the Competition Act or not. That is not a final ruling, it's just a prima facie ruling, and if the CCI makes that ruling, it then refers the complaint or information to its Director General, or the DG as we call it today. The DG of the CCI actually conducts the full-blown investigation, and that can include powers of summonsing documents or witnesses to provide testimony under oath, and also includes dawn raid powers, which we'll talk about later in the program. After the conclusion of this DG's investigation, it will submit a written report to the CCI with its finding and ultimate recommendation as to what the DG believes whether there is a breach of Section 3 or Section 4. Now, the CCI does not have to accept the DG's findings. It can accept or reject the investigation report of the DG and the DG's ultimate recommendation, and it will pass its final order. Now, the important thing to keep in mind is that the CCI by no means rubber stamps or accepts the DG's report. In fact, there have been several instances where the CCI has actually found differently than what the DG finds. So that's important to understand about the regime here, is that the CCI is the final arbiter of the Competition Act. Now, let me also mention one other thing. It is only the CCI and no other agency or court in India that has jurisdiction over an enforcement matter under the Competition Act. So, in other words, the Indian judicial courts do not have original jurisdiction over a Competition Act matter. That's very important for the next two bullet points, the last two bullet points on this slide. There must be a final decision on the merits for every complaint that the CCI takes. So if a complaint is filed, the CCI has to make a decision finally as to whether there was or was not a breach of the Competition Act. I'm not aware, frankly, of any other jurisdiction in the world that has where the competition regulator has this power. The CCI does not have the ability to refuse to take a case or to pass on a matter to the complaining party saying, you please file the matter in court because for any number of reasons we won't take this case. The CCI must take the case and it must make a final decision on the antitrust competition law merits. The other important thing is that in India, at least at this stage, there is no possibility of settlement once a complaint or information is initiated, and that complaint or information can't be withdrawn. This is going to have important ramifications, which we'll come to at the end of our presentation today. Now, let's come to the merger control issues that you must know about India, and these are, in our presentation, issues 2 through 7. Now, our first major issue on merger control, which we have called issue number 2, is you need to run 8 threshold tests to determine whether a transaction is notifiable in India. And we're going to run through those very, very quickly. But in the interest of time, I'm not going to dwell too much on the specifics. But what I would point out to you, if you are doing a transaction in India or that may in any way involve India, the financial thresholds determining whether you must file or not are, first of all, a mix and match of Indian rupees and US dollars, and you need to know both worldwide assets and turnover and Indian assets and turnover for the direct parties to the transaction, the acquiring group, the target, and for asset acquisitions only, interestingly enough, the vendor. And we'll come back to this point in just a second. Now, as I said, you have to run 8 separate tests here, and we've tried to outline in very, very brief form what these tests are. But you can see already that it's quite complicated because you must first look at the direct parties to the transaction, both India and worldwide. So right here, you have to do 4 separate tests, and the financial thresholds are listed on this slide. So even after you run the 4 separate tests on the direct parties, you then have to run similar tests for the group, both India and worldwide, turnover and assets. So I hope you begin to appreciate the complexity of the kind of information that is even necessary to make that basic determination of whether you must or cannot file in. Now, the third issue that you need to know about the Indian competition regime, and again, we're focusing on merger control for these next several slides, is that the form of the transaction matters in India, particularly with respect to certain formal and informal exemptions, at least in the view of the CCI. You can notice on the slide title that we say, but why? Because it's not abundantly clear when you look at the Competition Act itself why these distinctions should apply. But what is important for you to understand is the CCI, the Competition Commission of India, does look at the form of the transaction when it determines the potential applicability of exemptions. Now, if you look at the first bullet point on this slide, Section 5, which is the operative section of the Competition Act on merger control, applies slightly different threshold tests for non-competitor acquisitions, competitor acquisitions, and mergers and amalgamations. The second bullet point, however, on this slide is much more substantial and much more of a surprising result than you might otherwise think, and that is that the CCI's own merger control regulations make a much bigger distinction on the form of the transaction. So what we are seeing in India is that differential treatment is being given to acquisition transactions versus merger and amalgamation transactions for things like the small target exemption, internal reorganizations, and asset acquisitions. Now, the fourth issue that you need to know in India, and again, we're talking about merger control. Minority acquisitions are potentially notifiable, and again, we put in on the title of this slide, but why? And there's a reason for that. If you look at the first bullet point on this slide, the basic trigger of a merger control notification under the Competition Act itself, the basic statute that governs the merger control regime, requires there to be an acquisition of one or more enterprises. That seems like a pretty clear phrase, but unfortunately, it hasn't been construed that way. For example, a few years back, there was a view that if the thresholds were met, and here I'm talking about the financial thresholds, that even the acquisition of a single share of a company meeting the financial thresholds would be notifiable. So, for example, if I bought one share of company X, which is a gigantic conglomerate with huge turnover and assets in India, there was a view that that was a notifiable transaction. Luckily, the CCI has moved on from that, but the problem is that the CCI's merger control regulations don't seem to adequately address that phrase in bold in the first bullet point, acquisition of one or more enterprises. So, for example, the CCI's merger control regulations, and in fact in its decisional practice to date since merger control began in June of 2011, seemingly assert jurisdiction over non-controlling controlling minority share acquisitions. Now, some of the combination regulations have been lifted straight from the Indian Takeover Code, and again question whether a 25% non-controlling stake in a company meets that test in bold in front of you, acquisition of one or more enterprises. We're not making any value judgments on the interpretation, but it's important for you to understand that the combination regulations of the CCI, the merger control regulations, take a different twist on the meaning of the phrase acquisition of one or more enterprises. Now, issue number 5 about what you need to know on the Indian merger control regime is that joint ventures are notifiable, and then we put in parentheses maybe and or sometimes. And the reason we do that is that there's no definitive CCI guidance on this issue. And it's important to understand that the merger control provisions of the Competition Act do not specifically contemplate joint ventures. How you get to the potential notifiability of joint ventures is that phrase we talked about in the previous slide, acquisition of one or more enterprises. So the general view that has prevailed in India as to the notifiability of joint venture formations is whether the enterprises that are involved in the joint venture, meaning the subject of the joint venture, whether they are or have been, or in this case is or has been, engaging in a business or economic activity. If the answer is yes, in India, the common practice is to treat that as a brownfield JV, which also includes a new company that has been created for the JV co with a contribution of an existing or a previous business by one of the parents into the JV. However, for purely greenfield JVs, where neither parent is contributing an existing or former business into the JV, generally the answer is going to be that does not meet the basic test of acquisition of an enterprise, because an enterprise either must be a going business or was a going business. So the general rule of thumb in India is that greenfield JVs are not notifiable. And the last point on the slide here is whether joint venture in the Indian merger control context actually means joint control. For example, under the EU merger regulation, a joint venture for competition law purposes by definition means that there is joint control by the parents. That's not entirely the situation in India. There is not necessarily the concept of joint control, but it's something to watch as merger control develops. And keep in mind, as we talked about earlier in the slides, it's only 3.5 years as of the date of this presentation. Now, let's take a look at the sixth issue that you need to know, and I've actually put in what I think is a pretty telling picture. And this is something that I've written about in law journals, and I refer to it as the Dhaba Paradox. And this is an example of where the CCI is making a distinction on the form of the transaction. Because in India, there is something called a small target exemption, where the basic test at this stage is whether the true target has Indian turnover of greater than 750 crore rupees or 250 crore rupees in Indian assets. If neither of those tests are met, or sorry, if either of those tests are not met, then the small target exemption has been met and the transaction would not be notifiable. The reason I put this picture here is that this is what people in India refer to in Hindi as a dhaba. And a dhaba is a roadside eatery. But would you believe that that transaction, if, for example, Conglomerate 1 with gigantic Indian turnover sold that dhaba to Conglomerate 2 with gigantic Indian turnover, that transaction would be notifiable. So why is it the case that asset acquisitions have different treatment than other forms of acquisitions, for example, share purchases or voting rights acquisitions? Because in those two instances, share acquisitions and voting rights acquisitions, this small target exemption is applied to the true target. However, in the sole case of asset acquisitions, the CCI seems to be applying the small target exemption to the vendor. So, for example, if you've got Conglomerate 1 selling that DABA that we talked about in the previous slide to Conglomerate 2, and both Conglomerate 1 and Conglomerate 2 have very large Indian and worldwide assets and turnover, that transaction is always going to be notifiable, even for something as small as a DABA, which has very little turnover and very little assets, either Indian or worldwide. Query whether that's the right result, but the issue here is that you need to know that that is the general school of thought in terms of asset acquisitions. So please be very careful about this one. Now, issue number 7, and again, this one is an issue that you need to know about Indian merger control. There are exemptions, and then there are exemptions in quotation marks, which are informal exemptions. There are some exemptions with the statutory basis that are pretty clear cut. For example, the small target exemption. However, as we discussed in the last slide, that's not so clear cut because in the case of asset acquisitions, it's applied differently. But more importantly, the small target exemption itself is only applied to acquisitions. It doesn't apply, at least in the CCI's view, to mergers and amalgamations. So again, this theme that we explored earlier in the presentation, that the form of the transaction matters, does have an effect on these exemptions. And there's another statutory exemption for venture capital, investment bank, and bank acquisitions that's fairly straightforward. But then if we get to the second bullet point on this slide where we have exemptions in quotation mark, these are not exemptions, and it's very important to understand that because if you look at the CCI's merger control regulations, the actual language that the CCI uses is that they say that these kinds of transactions, which we list a few of them below, quote, need not normally be filed, close quote. So please do be very careful when you make the consideration of these exemptions that they're really not exemptions. They're just some guidance by the CCI about what kind of transactions should be filed and shouldn't be filed. Now, we're going to come towards enforcement issues, and these are the eighth and ninth issues that you need to keep in mind about the Indian competition law regime. And remember, when we talk about enforcement, we're talking about anti-competitive agreements under Section 3 of the Competition Act and abuse of a dominant position under Section 4 of the Competition Act. Now, issue 8, the CCI is clearly ready to enforce, and they're not just ready to enforce, they are enforcing. In India, we have fines already in the first 5 years of the effectiveness of sections 3 and 4, hitting potentially close to world record standards. For example, we've had a cement cartel where several companies were fined the aggregate of 1.2 billion, and that's with the B, dollars in US dollars, and that was in the first 3 years of the effectiveness of the cartel's provision of the Competition Act. So very important to keep in mind that the CCI shows no hesitation in fining in either cartel's cases or abuse of dominance cases and vertical agreements cases. Interestingly, on the second bullet point, abuse of a dominant position is actually a major focus in India, and that's because of the regime here. The CCI doesn't have the luxury of declining to take a case. It must take everything that is put before it. So we've seen a number of abuse of dominance cases where the fines have been quite high. And that's something that I think most people would have thought would be unusual in the first few years of a competition regulator's uh, existence, and that is going after abusers of a dominant position in such an aggressive manner with respect to fines. Now, something that a lot of people have been asking in the third bullet point is we've had some of these big cases, the cement case that I referred to, where the CCI fined heavily, versus a tire cartel case in 2002 where the CCI found that there was no breach. And that's a very positive sign about the CCI because it shows an openness of mind in terms of looking at cases on their specifics. One thing that we are very likely to see in the near future is the internationalization of competition law, and companies, for example, that may be involved in international cartels. We are probably going to see adjudication of those matters in the very, very near future because as India takes a role as a major world global power, it's very, very likely that cartelization issues, for example, will come up here as well as in multiple other jurisdictions. It's important to keep in mind also that information exchanges are quite troublesome in India, and in fact, in that cement case, the mere sharing of cement production information on a weekly basis that was not very aged in terms of the history of the data was found to be problematic. So be very careful about information exchanges in India, and please do not necessarily think that an information exchange without anything else among competitors is going to be immune under the Act. In August of 2014, India saw its first competition law, Dawn Raid, and this was a case involving JCB in terms of earth-moving equipment. Keep in mind that for Dawn Raids, the CCI, or more specifically its DG or Director General, has seizure powers. It's not just copy. So the CCI and the DG can actually enter a premises when they are issued a warrant by the Chief Metropolitan Magistrate of Delhi, and they can take the books and records and computers, take them back to their offices in New Delhi, and do forensic analysis, for example, of computers, smartphones, and other IT equipment. Be very, very cognizant about that. Now, in continuing with our eighth issue on what you need to know about the Indian competition law regime, it is possible under the Competition Act for third parties to make claims for being aggrieved by a breach of the Competition Act. In India, they make that claim to the Competition Appellate Tribunal, or as it's referred to here, the COMPAT. And the compensation claim provision of the Competition Act also allows for the potential of class actions. Now, there have been no final adjudication on compensation claims yet made, but the first claims are already being made today to the Compat. And in fact, as of February of 2015, there's one pending in the National Stock Exchange case, and there may be others that are not publicly reported. The other important thing to keep in mind about the enforcement regime here in India is that there is a leniency section of the Competition Act, and it's referred to in the Act as lesser penalties. Here, a marker system is used, so the first one in and the first one that perfects its application can get up to 100% reduction in a CCI fine. The second applicant may get up to 50% reduction in the fine, and the third applicant may get up to 30% reduction in the fine. Important to keep in mind that this leniency provision only applies to cartels, so it's inapplicable to vertical agreements cases and abusive dominant position cases, as well as non-cartel horizontal agreements. Second of all, it's important to keep in mind that a leniency application does nothing to a compensation claim. So the leniency application is only a vehicle to potentially reduce a fine levied by the CCI, but there's still exposure on compensation claims. Now, let me just take a very, very brief spin through the penalties that the CCI has levied in cases. And you can see here, and these are Indian rupee amounts, and the bars in blue are the fines that have been levied by the CCI, and where it's red is where the appellate tribunal, or the COMPAT, the Competition Appellate Tribunal, has actually reduced the fine. One thing that you can see here is that in these various cases, the fines have been relatively high. For example, we've talked about cement being a very, very large amount. Now, the reason I wanted to show this slide, it's a very interesting one. This advertisement actually appeared, I believe, in July of 2012 in Indian newspapers of general mass circulation. And this was actually placed by the CCI, effectively advertising the CCI's cartel leniency program here. If you look, remember those last couple of slides we talked about on the large cartel fines, and then you see an advertisement like this, it's quite clear what the CCI is doing, and that is being very aggressive on fines for cartels, companies, as well as abuse of dominance. But in this case, it's also having fines and then dangling the possibility of leniency there. Classic for competition regulators around the world, and it looks like India's following along other jurisdictions like the EU in basically having high fines on one hand and leniency on the other as your way out of a cartel. Now, we're coming to the close of our program today, and our ninth issue is a number of different things that you need to keep in mind. There has been criticism of the CCI and some of its decisions, and there has been action at the appellate levels regarding CCI's decisions. Keep in mind that under the Competition Act, the standard in which the CCI adjudges whether there has been a breach of the Competition Act is merely a preponderance of probability. Again, this is a civil standard. It's not beyond a reasonable doubt in a criminal standard. And in fact, in some cases, the CCI has found without direct evidence cartelization. For example, in the cement case in 2012, the CCI received a bit of criticism because the cement cartel case had no direct evidence of cartelization. But smoking guns are going to be found as the CCI starts using various investigative tools within its and the DG's powers, such as, for example, dawn raids. But keep that in mind. A preponderance of the probability is the standard. Basically, a 50% plus one chance that there was a cartel is the standard here. Some criticisms have also been levied at the CCI for its market definition, particularly in abuse of dominance cases. We didn't talk about abuse of dominance fines, but they have been very, very significant as well. And there's been some criticism at the CCI that the market definition has been rudimentary and needs more economics-based analysis. But it's important for the record, if there's an abuse of dominance matter that you're looking at, that market definition should be considered, even if it may not be considered by the CCI, that it's at least placed in the record for appellate review. Now, another thing that the CCI has been criticized about is that it has no fining guidelines. So some cases have been significantly reduced by the Competition Appellate Tribunal in terms of the fines. And so that's something that you need to keep in mind. There's talk that there will be fining guidelines, but to date, those have not been promulgated by the CCI. Now, there's some other issues here, but all of these taken together uh, are important to keep in mind that the CCI and India is a new competition regime. Over time, many of these issues will iron themselves out, but this is the environment in which competition law matters are being adjudicated, and frankly adjudicated in quite an aggressive manner by the CCI with respect to fines. Now, finally, we come to the last slide today.
So, ladies and gentlemen, in terms of this 10th slide, the 10th issue that you must know about Indian competition law, you can see that I don't really have any words on a slide. I think the main thing that I'd like to leave you with after today's presentation is that competition and antitrust law is quite new to India, but it's certainly a force that needs to be reckoned with. Thank you very much for listening to me, and please feel free to give me a call or drop me an email on the contact screen below. Thanks.